Yes or no? Because it's different.
It doesn't. The next paragraph.
We're going to disagree about that.
Well, let's just read what the appellate court
I can
says.
read it. I can read it, Mr. Steele.
I'm just going to conclude it. Contrary to the state's argument, the statute applies to all criminal proceedings, not
In which,
let me finish, not just those in which the defendant's
Getting real in
competency
here.
is at issue. In criminal proceedings, expert witnesses testifying with respect to the mental state or condition of accused cannot.
okay, I agree with you.
But
They can't testify about whether or not it's an element of the crime. That's the jury's purview. But
Right.
if it bleeds over into the issues that they're testifying to, they can't testify into a
mental state.
into the mental state in that respect. But that's a jury question.
But but what has the state been telling you? Our expert will say this is what that means. The court has said twice today, the experts of the state will tell you what they mean. They can't do that.
But whether or not, but Mr. We're going to disagree about that. Okay?
They can't do that. That's what.
All right, for everybody coming in, man, they having a motion right now, and we're going to get back to it. Then we'll go recap what all went on today. Him right there, that's Jack Gotti. For the people that don't know, if I'm not mistaken, it's 6 people who are going to be starting trial on the YSL RICO case in Georgia on the 27th, and that's the Monday after Thanksgiving. This motion right here is to see if their lyrics, if their rap lyrics can be used. That got Steele, that's Thug's lawyer. So they trying to get it to where they cannot use the lyrics. Of course, the prosecutors are going for the lyrics. Him and the judge are going back and forth. How they decide these things in court is they reference old cases. Like you'll hear them say such and such versus such and such that happened in 1964, and this and this and this and that is how they make it to where, okay, well, you're not going to be able to use these lyrics under these circumstances. The prosecutors are saying, nah, we are going to use these lyrics, but here we go.
Mr. Williams' intent by writing this is blank.
They
can just say, okay, this song, if you look at it from the standpoint of what's been written, blank.
No.
Yes, they can.
No, that's you can possibly, if you let it in over objection, the jurors can make those determinations.
Yes, they can. Yeah.
This is live for everybody coming in.
Recording. You can't allow then the expert to say, and let me tell you what they were thinking, what this means.
No, I'm not going to let them do that.
Okay, well, then that knocks out the intent. Everything they've been saying is the expert's going to say.
Well, then how are they going to, intent's a part, the element is, they're still going to have to prove it. So,
right.
They're going to play it.
That's right.
Or they're going to say, hey,
they're trying to get the lyrics taken out and the music taken out for the trial.
For whatever reason that you give it to.
And the jurors listen because anyone can listen to music. You don't have to be some expert. That's right.
Yeah.
So, okay. But thank you, sir. So to continue on that vein, the state has not shown today, and I understand it goes to authenticity. I'm going to go back to First Amendment, but they have not shown who wrote the lyric, whether it was changed.
I'll be right back, y'all.
When it was released, when it was recorded. That's another thing. Mr. Weinstein brought up something's 2013, released in 2015. The state hasn't said anything of when these items, any of the items. Mr. Weinstein said when it was written or recorded, but when was it really written? Was it written in 2010? Could you record something in 2013 and release in 2015? They have to prove that. And did Mr. Kendrick really want it to be? Is he under a contract where he has to perform in a music video? Mr. Williams is. He has to perform. He has to go to concerts. He has to sign memorabilia. He has to make himself public to take photographs. He has to do social media. That is all in his contracts. So for the court to get from the state that, hey, we just had this gang expert, who I know you said they're not going to be able to say it, but the state thought it until a moment ago, to say what this means, and we'll just determine when it was released, and then we'll just link it up to any crime we
Remember, they
believe.
can't state an opinion or an inference as to whether or not the accused did or did not have a
Exactly.
mental state.
No, they can't get into I'm not let somebody telling me why I said something. The jury can determine that. They don't need help. All right. So anyway, Your Honor, as the court probably knows, if it doesn't know, I will give this to you. I'll mark it as Mr. Do you have Exhibit 2 stickers? You have this.
This is Young Thug's lawyer for everybody. You see Young Thug right there with the green sweater on. That's Jack Gotti right there. And there's 3 others in court with them.
I'll do it.
Actually 4 who going on trial with them on the 27th. But this is Young Thug's lawyer speaking right now. You see Young Thug sitting right there.
Rules of evidence don't apply here. It's not stipulating the authenticity or veracity of the content of it.
All right.
Your Honor, I'll mark Mr.
What's
Williams
good, everybody in the chat? Shout out to all y'all. Appreciate y'all tapping in. This is on Law and Crime Network. Once it ends, I'm going to go back through and go over some key stuff, and we'll listen to the lyrics a little bit.
And Andrea, A-N-D-R-E-A, Dennis, D-E-N-N-I-S. May I approach?
You can.
Shout out to Slab Life. Shout out to everybody who here. They probably gonna mute this part when they approach the bench, so while they got it muted, I'll speak. That's Jack Gotti right there. Some of his lyrics were read earlier today. Shout out to all y'all, man. It's getting real. It's getting closer to the wire. The trial is pretty much officially begun. The start date is the 27th, but they got the jury selected.
You will see
how the mic sound.
Everything's backed up by peer-reviewed articles. Hip hop is a more than billion dollar industry all over the world. It is the largest economic engine for people who come from depressed minority communities.
Let me cut these subtitles off.
Hyperbole. It is filled with untruths. And it changed our world for the better. We now speak differently. We use words all the time like slime and slat. The word N is no longer
the word in, huh? Nah. I feel you right now, though. I feel you. But nah, we ain't making that. I feel you, though, Judge. I feel you, though, still. Get it off the word in, because niggas do be using it. But we got to take that word back after this trial still. We ended that after this trial.
Okay.
But for this trial, I got
fashion has changed based upon hip-hop or rap.
Facts.
Gang signs are commonplace. At the Super Bowl, we had a well-known person in the hip-hop industry making signs with his hands, signifying the Crips in the past several years.
Whoa.
And that's okay because it's America. You can make a gang sign. You just can't commit some sort of criminal street gang activity.
Hey.
And now the state wants to use all of this.
Got a point.
Economic brilliance of Mr. Williams and others in this trial, and the court should stop it. The First Amendment, Your Honor, is the difference in America than most.
This is interesting. We're gonna let this play out. We're gonna tap in for people that's just coming in real quick.
Freedom. I heard you say it.
This is about lyrics being
When we
used.
started this process on January 4th. You told the jurors they have every right for redress, to say what they want to do. You took it on yourself. You said, be mad at you. Don't hold against anyone else. But you said, but right now, this is what we're doing. We all come here because we have a duty. And there's other people you talked about. It was beautiful. I mean, everybody paid attention. Who gives us that opportunity to be free. Your Honor, there are a number of cases. May I approach, sir?
You may, sir. You have the ability to freely walk around the courtroom. You don't need to ask.
Now, the case I just handed to the parties in this honorable court is Rodriguez. I mentioned it earlier. It's RDRIG-UEZ versus State.
We've heard of Rodriguez a bunch. So
Yeah,
what is
Rodriguez.
it you want to tell me about
It's a
Rodriguez?
big case, 284 Georgia, 803. If you look on page 2 of the copy I've given the parties, it's actually in our statute. It's in Division 1. Our highest court wrote, it's in Division 1, which on the left-hand side. It's the 8th line down on the right. Consistent with this principle is the following explicit statement by the legislature regarding its intent. It is not the intent of this act to interfere with the exercise of the constitutionally protected rights of freedom of expression and association. The General Assembly recognizes the constitutional right of every citizen to harbor and express beliefs on any lawful subject whatsoever, to associate lawfully with others who share similar beliefs, to petition lawfully constituted authority for a redress of perceived grievances, and to participate in the electoral process. I am skipping the rest. I mean, I could read it, but I'm skipping to the last page, Your Honor, 7 to 7. It's in Division 4. It's on the left-hand side. Our highest court wrote, contrary to appellant's further contention, OCGA section 16-15-4A, as properly construed, does not directly or indirectly infringe upon the First Amendment right of freedom of association. The act of associating with compatriots in crime is not a protected associational right. To support a conviction, the accused must be shown to have conducted or participated in criminal street gang activity through the commission of an actual criminal act. Mere association is insufficient. OCGA 16-15-4A comports with due process requirements because it punishes conduct, not association. It does not unconstitutionally criminalize membership in an organization because the statute does not impermissibly establish guilt by association alone. Moreover, the right to association does not provide protection to those organizations that commit a felony. Criminal gang activity is not protected activity, even when committed by a group exercising a constitutional right to free association. In this case, Your Honor, what we have here is Mr. Williams' association with others is what the state is saying without committing an act. They are saying because he is singing about it, he is now part of a crime.
No, I don't think so. I think that they're using his particular lyrics for other purposes. They're not, like I said, they're not criminalizing the fact that First Amendment's not on trial. It's not. It's not on trial.
But what purpose are they using for?
They're using it to show the issues that they're allowed to do by statute.
Specifically, though.
By 16.
No, specifically. They are using his words to say he is a bad man.
No, they're
Who
not.
is part-
They're using his words to show that he's involved in a gang in contravention of count 1 in this particular indictment.
But that's a general statement.
No, look, if it's for a particularized purpose,
Well, this
They
shit
can
here
show
getting
particular-
real.
I agree.
This shit getting real, man.
They just come out and say he rented a car that was used in the killing of Donovan Thomas. Do you realize that Mr. Williams is not charged with the crime of murder? It's in the indictment. They didn't charge him as a party to the crime. They separated that. They didn't even allege it as a predicate offense.
remember, Mr. Steele, evidence can be used for different purposes. It's not that they're using this. You're absolutely right. I can't show, you can't show guilt by association. You can be a member of a gang, and certainly, you can certainly say things, have opinions, be, prolific in written speech, acting, dance, and other things because they are protected by the First Amendment, but you can't do things that would be criminal in nature, and then because then they wouldn't be protected speech.
I agree with
Or
that.
acts.
But that's what you have to do. So you have to go lyric by lyric and then link it up. And that's what the state did not do. They're giving you broad statements in the state, and there's others. In 303 Creative LLC versus Lenis, ELENIS.
But I mean, they're telling me how the statement or the particularized, the admission, the relevant portion, and the admissible against. Now, whether or not that is the jury believes that, or whether or not it's admissible under a threshold issue is what I'm asked to being considered today. They still got to show foundation. They still got to prove, hey, you sang it wasn't changed, it's attributable to your client, and then it's got to be admitted for a proper purpose. Well, he didn't necessarily have to write it. He may adopt it. Maybe it's tacit admission. So it just really depends on the circumstance. So preliminary threshold that they're asking me to look at, it's still going to be subject to, I would say, several objections or potential objections at trial.
Well, the first one is the First Amendment, and I have a habit of this.
Just you. Why don't I just recess in place? Deputy Ingram?
We hear everybody. I think they finna do a recess, so we'll chop it up real quick.
How long will it take?
They taking a recess, so we gonna chop it up real quick. Hold on real quick, y'all. Trying to get something together.
Okay. Yeah, I don't think it's going to be bad. Okay, all right. We're waiting on Miss. Do you want to come back? Okay. Okay. Coke would be good. Coca. Yeah, Diet Coke.
Hold on.
No, I'll just take it. Take it anything. That's fine. Yeah. It's fine. Okay. Here's Mr. Williams. All right. Do we have everybody back, or is anybody missing?
That was a quick recess. Shout out to everybody in the
Mr.
chat.
Williams, you good? Okay. All right. Okay, Mr. Steele, you can continue with 303 LLC, Creative LLC versus Lennis.
That's 143 Supreme Court 2298, 216 Lord Edition 2D 1131. It's a 2023 case. It was decided June 30th.
Okay, what's the caution on it this year? Pursuant to the top of the case,
I don't know why.
caution is of 8 November 2023.
That's when I printed it. I cannot tell you. I'll look at the caution. I mean, it's our highest court, so I'm not so sure.
303 Creative LLC versus Elenis, ELENIS.
I will answer that question. I didn't even notice that. Thank you.
All right, so what do you want to tell me out of this case? What page?
If you go to the very bottom of page 9 on the right,
All right.
our highest court wrote, the framers designed the free speech clause of the First Amendment to protect the freedom to think as you will and to speak as you think. They did so because they saw the freedom of speech both as an end and as a means. An end because...
So we're going to go back in a second, y'all. He just reading some things to the judge right now. They read a lot of lyrics today. I'm going to put something right here real quick, and then we'll come back to where we at in real time. But there goes some of the lyrics they read today in court. They brought out whole billboards. This is the prosecutors. This is what they're going to do. The motion is about, are we going to play the lyrics? So for people here, I want to let y'all hear that real quick because y'all might have missed that. I don't know how many of y'all was able to see it. Young Thug is in the courtroom right now. This is Thug right there. Play some of it for y'all. That's Jack Gotti right there. That's Thug.
Number 3.
This is the guy I don't know. He's on trial also, though. He on trial back here, too. He on trial.
Yes. Next, Your Honor, I'm going to do it simultaneously. Will be State's Exhibit number 4.
I think it's one more.
State's Exhibit number 4 has Mr. Quamavius Nichols and Mr. Stillwell in that image, again showing association with each other.
We put on the lyrics, then we'll go back to real time. She reads a lot of lyrics from different songs. Here we go.
Another show their participation and allegiance into this gang. He also says YSL won't fold, pick his ass off the balcony. Again, this is a reference to YSL criminal street gang members not folding, not snitching, or cooperating with law enforcement. And there'll be another lyric that is similar in nature to this as well. And again, as the state just mentioned, the YSL Wife and Nigga knows what that reference is, which is one of their symbols that they show their affiliation and association with this gang. This statement would come in against Mr. Williams as a party admission, and then to all of the other co-conspirators as a co-conspirator admission and declaration against interest. The third lyric in this grouping of lyrics would be from the song Really Be Slime. Now, this is a song on the Young Stoner Life, Young Thug, excuse me. This is on the Slime Language 2 album, Your Honor, which is a compilation album, which is a compilation album by Young Stoner Life, Young Thug, who was Jeffrey Williams, and Gunna, who was Sergio Kitchens, both Mr. Williams and Mr. Kitchens being co-conspirators in this indictment. And we have an individual by the name of YNW Melly, who says this as the chorus: "My niggas really be slime and we committing them crimes. Hop out and shoot." And then we have B Slime, who was another, who was an individual who was not, who's an individual who was not charged in this indictment, but he says, "Wanna be slime, go catch you a body." Here, Your Honor.
Y'all see how they got that whole thing up in the courtroom?
Rico, my niggas really be slime and we committing them crimes. We have all of the individuals in this indictment charged in the predicate act. Each and all defendants are charged with the 191 overt acts, some of which are predicates. We also have that in count 1, Act 17, 79, and 173, which all deal with the shooting deaths of both Donovan Thomas, which is also count 2 in the indictment, Jamari Holmes, who was murdered as well, who that's part of this indictment, as well as Shamel Drinks. Each of those individuals were all murdered, and it's the state's contention that when they say, "Wanna be slime, go catch you a body," I mean, you go out and you go murder someone. That's how you can become slime. You go murder someone and you go catch a body. And we have these 3 individuals who were murdered as a part of this indictment. When you look at this particular admission, Your Honor, again, these admissions go to show the enterprise because of how this song shows that these individuals talk about being slime and being part of YSL. Again, slime being one of the phraseologies that each of these individuals call themselves or talk about being a part of YSL. We also show that these statements will come against all the defendants as a co-conspirator admission and a declaration against interest. It would come against Mr. Williams as an adopted admission because he is the person who put this compilation CD out. So these statements would. All
right, y'all, I'm gonna go back to real time real quick to see where we at.
And I'm advocating that you need to go lyric by lyric, video by video to determine, and the state shouldn't be doing, "Oh, we'll just tell you some and we'll do others," because we're gonna have to do this during trial. Because these are protected until you say they're not.
No, they may not be protected, period.
But
that's the thing, Mr. Steele.
But how would you know? You make that determination. You're armed with these cases to determine what is protected speech. So you need to do that. Here's 2 other cases, sir.
He bringing up the information. Thug lawyer making some good points. Most definitely.
This is Counterman, Counterman versus Colorado. This was decided 3 days before the last case that we just talked about. 143 Supreme Court, 2106. 216 Lawyers Edition 2D 775 2023 case.
Okay, what's Counterman going to tell me? That wasn't always already cited in 303 Creative LLC. What different proposition do you want to tell me? And again, we have another caution on it.
Yeah,
as of 7 November 2023.
Yeah, well, no, that's when I printed it, but there's a caution there. I don't know why there's a caution. It's the highest court, and it was decided.
Yeah, that's what
4 months.
BP. That's exactly what the lawyer said. He brought up even like everybody using rap lingo.
The last question, which I don't think it's a difference without a distinction.
I'm trying to find something.
But this is a criminal case. This is a stalking case, and this broke new law because now the U.S. Supreme Court, in a 5-justice majority opinion, said you need a mental state of the speaker for the first time, and
What
they
page does that show up on?
if you turn to page 4 of 42.
4 of 42?
Yeah.
Okay, all right.
The very top of the page, the last word on the first line, on the left-hand side. The question presented is whether the First Amendment still requires proof that the defendant had some subjective understanding of the threatening nature of his statements. We hold that it does, but that a mental state of recklessness is sufficient. The state must show that the defendant consciously disregarded a substantial risk that his communications would be viewed as threatening violence. The state need not prove any more demanding form of subjective intent to threaten another. And that's a stalking case. So
hold on real quick,
what
y'all.
you have here is now you have
I'll be right back.
go on the rubric and you need all this information, which the state did not give you. What is going on at the time of the release of all these videos, of all of these songs? Because I'm saying that they're
Okay, but wouldn't that be a jury? Wouldn't that be an issue that the jury's got to decide whether or not whether or not the remember mens rea and actus rea. So did they there's always intent that has to be proven with anything, and it can be proved by the state by direct or circumstantial evidence or both. So why wouldn't it states the obvious, Mr. Steele, in terms of still requires that you have some, it says right here, do what you just read. So I don't have any disagreement with that.
but it's immunized. It may not be the right word, but it's immunized. It can't come in. It's protected speech. It can't go to a jury until your court says this is not a true threat. And the state is using it for a true threat. They said to you today, these are threats by YSL. They are saying these are true threats.
No. They're using the line of whether or not it can be, just for the other purposes, if it's 16-14-4, 16-15-4, or any of the other intrinsic evidence statutes that apply this case.
Yeah, you have to first go through and say, is this a true threat? They are saying these are threatening words. We are telling people, don't mess with us. Ms. Hilton said, we're telling the world we're YSL. I'm the principal. And you could come in.
But I think that's different because you've got with the case you're giving me now in Counterman. You got a stalking statute, right?
It's a stalking.
It's a stalking statute. So the statements that that are here, they're saying that related to show his statements were objectively threatening. Also, he was aware of their threatening character. So that's a little different than what the state's trying to do or solicit, whether or not these lyrics are admissible for other purposes.
But they have to state why it's not a true threat. I mean, excuse me, I said that wrong. Why it is a true threat. I'm saying it is not a true threat case. None of these lyrics are true threats. Therefore, it's protected speech. And if you turn to page 17 of 42 of Counterman, this is the concurring opinion, but this may answer the court's question of why do you have to be the guardian before the jury that then gets to determine. It's on the right-hand side, the last paragraph. And it reads, the burdens of over-criminalization will fall hardest on certain groups. A jury's determination of when angry hyperbole crosses the line will depend on amorphous norms around language, which will vary greatly from one the community to another. Juries' decisions will reflect their background knowledge and media consumption. Speakers, go on to the next page, whose ideas or views occupy the fringes of our society have more to fear. For their violent and extreme rhetoric, even if intended simply to convey an idea or express displeasure, is more likely to strike a reasonable person as threatening. Members of certain groups, including religious and cultural minorities, can also use language that is more susceptible to being misinterpreted by outsiders. And I stress this. And unfortunately, yet predictably, racial and cultural stereotypes can also influence whether speech is perceived as dangerous. And they cite Dr. Adam Dunbar and Dr. Kubin. Dr. Kubin hasn't been here yet for you, but Dr. Dunbar has. Threatening nature of rap music. So my point, to answer your court's question directly, like, why can't the jurors just do it? The court is telling you why.
That's what they're saying, a jury's determination of it. I mean, crosses the line, but they still get that privilege of deciding that.
No, the point here is it protected speech? That's what that's what I just read to you. You need to decide whether a jury gets to hear that evidence. And you only do that if it's not protected speech, if it is a true threat, if it is something that the state is saying, or is it just simply
Mr. Steele,
music?
I think it's two tracks. I don't understand the argument, okay? I really don't. It's two tracks. It's either First Amendment or it's not.
And you make that decision.
Okay. All right.
That's what we do.
All right. Okay.
But you have to make that decision.
Okay.
I hope I've answered that. I mean, your question is right there. And what is a true threat? That's the next case, United States versus Bagdashian, Bagdasarian. It's 652 F3rd 11.
For people that's just coming in real quick, let me tell y'all what's going on.
And this is hard.
We'll go back a little bit. I'll probably drop a video on it tomorrow. This is the motion hearing about lyrics. Trial is starting on the 27th of this month. That'll be the Monday after Thanksgiving. It's Young Thug and 5 others going on trial. They played some lyrics today. This is Young Thug's lawyer, Brian Steele. He's in there combating the notion of their lyrics being used against them. The lyrics are being used as evidence. They went through it already. Y'all can go look and see. They're saying that Young Thug and them are rapping about murders. They specifically spoke on it. You'll hear it yourself when you look at it. I'm not making this up. It's right there. They talking about YF and Lucci crew. They named 3 people that they said somebody allegedly, they're saying that they killed these 3 guys, and these are the lyrics that back it up. That's what they claiming. Young Thug's lawyer defense is, hey, they're artists. Hip hop is music and entertainment.
Has done anything right? Question mark, question mark.
So what they do is he goes and finds other cases to represent that notion and that claim of, well, nah, these lyrics can't be used. And that's what they do in court. It'll be like the state of such and such versus such and such. In this case, 1979, it said this and this and that. Y'all have probably seen them type of things before.
Executed him.
Did they prosecute him?
Of course. He was convicted. He was convicted of 18 U.S.C. 87983. He was convicted. Your Honor, they go through the analysis. That's what I'm asking respectfully you to do. You are the person, you're the only person on this earth who can do this. And you need to do it this time because I'm asking the court respectfully. Jeffrey Williams, if you let this in, nobody should ever say anything to anybody else. Because the state of Georgia went through with all their resources and picked out little, they don't give you you have not listened to the whole song. of any of these. You don't know the context. You don't know the next line. The words are good as the company they keep. The state is telling you this is mens rea. It doesn't, they can't say whether it's mens rea. The jury makes that determination. What they should be able to say is Jeffrey Williams told KC that he wrote the song about the killing of Mr. Thomas. That is competent evidence. That is the confession. That is the co-conspirator admission. That is the admission. But what they're doing is not that. The state is making the determination. Judge, we have these violent lyrics and we have these violent allegations. So therefore, we want to merge them together and let the jury decide. And that's exactly what the U.S. Supreme Court says cannot be done because that's not America.
Okay, but, and you're right, I have to let it in. I have to decide whether to let it in, whether or not it's gonna go for a proper purpose. So you're right about that. I don't have any issue with that.
Well, first, is it protected speech? And the state, my point, I sat here intently listening. There's wonderful people and lawyers representing the prosecution. They never gave you the information to be armed with getting it in. They need to bring it. I moved to exclude it as protected speech. I'm not asking for any category of, I don't remember what Mr. Carlson said, but it was far-fetched. I'm not asking for any somehow carve out. I'm saying that I would do it if it's a book writer or if it's a teacher. These are words. And the words in America get to be protected unless, of course, they're not. Now, certain words you don't even need to do First Amendment. If you're in like what you're doing now, and I answer questions you directly, that's not a First Amendment. That's not my beliefs. I'm answering your questions. We're having a conversation. I said that. But when you're going into somebody's mental state because they're rhyming words to beats and making people feel good about them because they play them all over the world, that should not be interfered with unless the prosecution meets their burden to show it's not protected. So this is a great case about, is it a threat that Ms. Hilton talked about? The last case I gave you, Your Honor, which was a Counterman case, they have great about incitement. You know, when you're inciting people to do things, go out, I'm going to tell you this, go out and go to January 6th and go to the Capitol. Those are not protected speech. If it's to incite somebody to do a crime, I agree with them. I'm not trying to say that criminality somehow gets immunity because you said it in a rap lyric or you say it in any setting. I'm saying in this setting, in this case, without a connection, I think you called it nexus earlier, maybe not today, but earlier, unless there's some sort of direct connection to show, hey, this is the confession. That's the state's theory. So it should not be used. Your Honor, moving on, there is a trend here. What is going on across America is the trend. It is not fair for you not to be alerted to this. God bless you. In California statute, it's 352.2, admission of creative expressions. They passed a statute.
Mr. Steele, that's not relevant for my analysis. It really isn't. I mean, just because other states are doing whatever, I have to apply Georgia law to these facts and circumstances, and the law as it relates to our highest courts that I'm required to do. The fact that another state may have enacted another particular statute is not really my consideration at this point in time.
I'll go fast, and Louisiana did the same. But how about the fact that there's a federal bill pending?
What does that have to do with this case?
You don't want to know that this has been attacked. These rap cases.
This is the case we find ourselves in at this point in time.
But don't you want to know that this is going on across our country, and the legislatures got involved
It's getting real.
to say you need to do this analysis?
But they haven't yet. So I mean,
Not
so I
sure.
can't. So I'm not going to consider that because it wouldn't be proper for me to do so. So I have to apply Georgia law to these particular facts and circumstances and those cases that are directly relevant.
Okay, Ryan.
So the fact that another state may be enacting laws that prohibit lyrics or the introduction of those is not of consequence for the case that I have right here. Yeah, it's something that other states are doing, but
And the federal government, it's not done. I don't want to say they did, but it's legislation.
okay. All right. So anyways, all right. What else do you have?
Excuse me, I apologize for interrupting, but feed to the 8th floor is no longer air, and I know my client's family is unable to. There's somebody there. There's somebody in a. Well, I think it's because they came down here trying to get to this courtroom. That's the feed is up, but I think they should.
I think that.
I apologize.
Yeah. In fact, the feed's up right now. I can see it from
It
here.
just doesn't have any. It doesn't have the gallery just.
Okay. All right. Continue.
Okay. I'd like you to look at United States, and I'll email you this if you don't have it. I gave it to you, I think, previously, but it's United States versus Williams. Just in the district court, the District of Arizona. It is CR-18-01695 TUC-JAS. The district court adopted the magistrate court's order, so it is the district court's opinion now. And this went through exactly what we're talking about today. And in the discussion section, the court discussed the First Amendment. And then
For everybody just coming
the
in,
court said that
The-
all courts recognize
this is a motion
the
over
significant
rap
concern
lyrics.
with the admission of
I don't think
Gen Z
anybody who would want, who's going to trial in any form, shape, or fashion, any rapper you listen to,
music
would
at
want their
trial
lyrics used against them
is
at all.
that the lyrics present a serious risk of inflaming the jurors and influencing them to convict a defendant on impermissible grounds. They cite cases from across the country. Courts have also universally recognized that rap music features fictional imagery, metaphors, and exaggerated storylines. As a result, it is difficult to identify the probative value in fictional or other forms of self-expressive endeavors because it cannot be presumed that the author has acted in accordance with the views that he wrote about. Repeatedly, rap music can mislead or confuse the jury because it will become a feature of the trial and overshadow the acts giving rise to the charges. Thus, the risk of inflaming and influencing jurors to the point of compromising a defendant's right to a fair trial is a significant factor to be considered in determining whether to admit rap music. The probative value of rap lyrics is greatly reduced when it is unknown, and these are all the things we've been talking about, Your Honor. 1, who wrote the lyric? 2, when the lyric was written. 3, when the song was actually recorded and perhaps edited, and or when they were uploaded to YouTube or similar social media. In fact, the inability to differentiate between fact and fiction.
I'm reading
is
up on some stuff on it over here,
when the
y'all.
author of the lyric is not known. The government plans to explain ambiguous lyrics and not the individuals who wrote the song.
That goes to foundation. Wouldn't you agree?
Well, it's under 432.
No, but wouldn't it, I mean, if the states, and wouldn't that be subject to objection? I mean,
Yes.
Man, I don't know how it's gonna go.
No, I mean, when the evidence is presented,
We'll see.
if they can't show who the person is that wrote the author of the song, and like you said, if it's been edited or changed, and the like, and it doesn't fall within some other particular exception, it's foundation, right?
It's,
I mean, I'm not saying, I mean, look,
yeah.
anybody worth their salt is not going to say, okay, hey, here's a snippet and it's admissible. No, they've got to get in there. They've got to get in the other things that would lay the foundation for that.
I thought that's what we're doing today, though. They didn't do it.
No, this is a preliminary. The state's asking me for, preliminarily. They've asked me, and if you look at what they've asked, Mr. Steele, they've asked me.
Here we go. This is key right here. This is key for everybody here. This is something to listen to.
Georgia's written, evidence statutes is written. Conditionally admit particularized lyrics, conditionally admit pending lyrics, and deny your defense motions. However, Mr. Carlson did mention earlier that, of course, this is subject to foundation.
But I didn't, my motion's being heard. I have a motion to exclude. I raised all this.
Okay, yeah, but it pertains more so to the preliminary issue. And it's not that it's not going to be subject to other things. I mean, so, Mr. Steele, you'll still be given it, depending on whether or not how I rule in this particular case. I still would believe that you would have some other objections if the state didn't lay an adequate foundation. I may be called to rule upon some whether or not that's been properly met. But this presupposes that the state, can lay some other foundation as to the things you just aptly pointed out.
And get around the First Amendment.
Of course.
All right, and this, in the same case, Your Honor, from District of Arizona, they talk about it's in Division 2.
Is this a federal
Yeah.
case?
Yeah, Federal District Court from Arizona.
So it's for persuasive authority, correct?
Oh, yeah, it's every case that the state cites you except the Georgia case.
All right.
And U.S. Supreme Court, yes.
All right.
In Division 2, the court goes through a very detailed analysis, which is what I'd like you to do.
This is Fulton, if I'm not mistaken. But
we have a tremendous, this is not.
Some people in Fulton County, some in Cobb County
Is
on this
69.
YSL trial.
Page 69?
Yeah, of 101.
69 what?
Of
101?
Yeah. I'm going to email you this if that's okay with you. And I'll email the party.
Why don't you email everybody that and I can take a look at it right now.
Okay, let me pull it up.
All right, why are you sending those emails? There are people who was in the YSL trial because he's sending the emails over to him. We'll do this. We'll talk real quick. There are people who on the YSL trial who initially got arrested. Some were in Cobb County Jail. Some were in Fulton County. Right now, it's 6. It was 20-something total arrested, either like 24 to 27. I can't remember the exact number. And out of that 24 to 27, we now have 9. 9 have taken plea deals. The others who are on this trial, their trials will be separated from Young Thug's. So it's Young Thug and 5 others who are on trial right now in court today. We had BB take a plea deal at the end of last week. But everybody else is going to trial for it right now. And this motion is about the lyrics being used in court. The guy with the gray hair, with the white hair, that's Thug's lawyer, Brian Steele. Steele is also the lawyer that got Young Thug's brother a life sentence taken back. Let me see if he got it yet, y'all. Hold on. See if he got the email. Oh, okay, they still haven't sent the email. So he waiting to get an email from Thug lawyer right now that he's going to read. This is a real critical point. It sounds like the judge is saying these lyrics can be used. You're going to have the right to object them while the trial is going on. What I'm thinking he looking for and what I'm gathering, he pushing to where, hey, y'all can't use these lyrics at all, which that makes sense for anybody who going through something like this, nigga. I don't care who you is. If they put your lyrics in the court, whether you did it or not, nigga, with the image that Thug got, the image that they got, niggas got tats in their face, dreads. Of course, the jury is not supposed to judge them by that, but if you reading off murder, kill, rob, steal, shootings, even if you caught a dope charge, nigga. I'm gonna use an example. This just for instance, so people can know. Not saying that this is true. Let's just say, for example, Jay-Z caught a dope charge, right? Let's just say that Jay-Z caught a dope charge. Jay-Z lawyer would do everything in his power to make sure that his lyrics couldn't be used in court. Same thing for Pusha T. Same thing for...
Yeah,
Okay, just send an email. Okay, we're waiting on this email to come through still. So that's what this is about. Shout out to everybody in the chat. We bring you the real live in the flesh. This is on Law and Crime Network also, bro. It's all in Fulton County. They just being held in Cobb. That's what thugs being. Yeah, I knew it's all the same thing pretty much. I mean, they all right next to each other, correct? But I figured this was a Fulton County case, but they just been having some of the people in Fulton, some of the people in Cobb. But yeah, Thug has been in Cobb County the whole time. They did show that. They showed his cell and everything. This has been a long time coming. They got picked up a year and year. Then they bought shit. What?
Christina, I emailed you Mr. Weinstein's phone.
They're a year and a half in. They're about a year and a half in. They're about a year and a half in, bro. Now, the judge did have a recent outburst. The judge did have a real recent outburst. He was upset because certain evidence was still supposedly getting presented. And he was he's like, man, y'all got a cutoff date on this stuff. For everybody coming in, we waiting on Thug's lawyer to come back with an email that he want to send to the judge. They try to make these lyrics not be able to be used.
Do you have a copy of that case, Mr. Seal?
I have a written copy.
And it's crazy because in Atlanta right now, it's kind of late to be in court in Atlanta. It's kind of late to be in court in Atlanta, man. 7:30, if I ain't mistaken. It's going to be 8 o'clock in Atlanta.
I'm not getting it right now, but do you have a YSL site?
No, I have the original site. You can get it from. I have the site. Yeah, I have the site. What am I talking about? It's you want Westlaw?
Yeah.
I don't see Westlaw on here, but it's 120. Oh, that's wrong. It's 2002. Well, I have a Lexus site. Is that okay? You don't have Lexus?
I don't have Lexus.
Okay. But the email should come through. And I sent it to Mr. Kern separately because I left him out in the first one. Did you get yours?
Where's the, just give me a citation, Mr. Seal. You said 5 what? 5?
No, he was talking about something else. It is, well, I have the Lexus site. They don't give on my copy, they don't give
Never mind, it came.
Okay.
What page, sir? What page is this analysis you're telling me that I need to apply? What page of 62 does it apply on?
Let me see. because it's a different format, but hold on one second.
Your Honor, there are two cases from a similar time period there under Williams from that same federal magistrate.
Hello, y'all.
The state is aware of which date case.
The one, yeah, there's.
It's the one you have.
The one that's on the side on December 9th, 2022, filed CR-16955-TUC-JAS parens EJM close parens. You're welcome, sir. What page, Mr. Steele, of 62?
I'm getting it right now, sir.
Mr. Steele, I think you cited this when one of your experts was testifying. So
I did. I think I gave you the case.
you did give me the case. So yeah, I seem to recall it now.
It's on page, if you want to know, it's on page 37 of 62.
All right.
On the right-hand side.
Let's go on to that now. All right, I have it.
And that's what I discussed with the Honorable Court. And then what I was just discussing when you asked for the the case.
Where in this, where does the analysis or that you're referencing to that are you suggesting I take it into account?
Everything, but it's under discussion, which is what I just cited you.
On what page, sir?
37 of 62.
I get it. Okay, I get it. Okay.
And then I skipped
I'm with you.
to the next analysis, which is just a couple of pages later, which if you look at, I discuss this on page 39 of 62, the very bottom right,
Okay.
danger of unfair prejudice. And then what I was just discussing when we stopped.
Honey, were you just financing over there?
There's no interest here, just financing.
And you financed him even after you saw how little he's working with?
Oh yeah, finance is not a bad word at Cons. Shop Cons Black Friday sale now.
Facts, and your expert, was testifying to this particular agent's experience or lack thereof in interpreting rap lyrics. So that's part of it. And the other thing is the lyrics are heard differently based on the listener. I do remember that. The lyrics do not mirror or exhibit an unmistakable factual connection to the charged crime. So that's something that when I mention that nexus or other things that the state has to be able to prove. So it's
We can't hit the skip button. All right, so this is a long process.
Which if you look at,
Trying to see what the clock say out there.
I discussed this on page 30.
Our head. I'm surprised they in there this late today. All right, until they get back, we'll go back real quick. Y'all want to go back and look at the part where they was reading the lyrics and stuff? It's on y'all in the chat. Or y'all want to just sit right here in real time?
Did you email it around to everybody?
It's on y'all. We'll just sit right here and wait. Politic. I'll tap in with the chat until they kick it back up. Let's do that. You going through the emails and shit. Nah, facts, Jerron. That's fact. Condolences on that. I blame us. Lyrics. I want to go back to the lyrics parts. Give me a majority on that. Give me a majority on that. We'll go back to the lyrics and hold on. Let me see what he say. This is live on Law and Crime Network too. Law and Crime Network. They get a lot of. They be everywhere with this shit. They covering the Keefy D shit. They covering this shit. They doing the YW Melly shit. They doing it all.
The author of these lyrics was not known. The government wanted to use the lyrics as the defendant's confessions of the charge crime.
That's
Lyrics were so highly inflammatory that there's great risk that the jury would convict the defendants for impermissible reasons. And thoroughly misrap songs and videos. And then they used Agent Parkinson and Professor Nielsen. Had the potential to become a feature of the trial and overshadow the acts and give rise to the charges. And so they didn't think that this particular testimony was helpful to the jury. They thought it was going to be misleading. The judge wrote confusing and misleading to the jury.
That's 403. That's what I'm saying. And what the state said in their proffer, Your Honor, if you think it through, and it's in Division 2 of the page I just gave us on recording the parties, they said that they have they have recordings where Mr. Eppinger is calling people to ask whether Mr. Williams approves the killing of Mr. Bennett. They have recordings of Mr. and I forget his name right now, about killing Mr. Bennett, Mr. Myrick, about killing Mr. Bennett and asking Mr. Williams for permission. They have 191 overt acts. They have 191 overt acts. Do we really need to spend all this time on these videos and lyrics? And that is under Division 2 of the case, United States versus Williams, that we're discussing. And it's on page 43 of 62, and the court excluded the lyrics and the rap songs and the videos. And that's what I asked you to do. So it's 403, not only the prejudicial value substantially outweighs any probative value, we have the same issues that are lined up in Mr. Williams' case. And when I say that, not Mr. Jeffrey Williams, the case in Arizona, where we don't know the author, when it was written, the lyric, and what it applies to, and it's generic. These lyrics are generic. They're not specific, going back to the Second Circuit case in United States versus Carpenter that we discussed earlier, that the state cited. And then, Your Honor, this will add great delay. When we have a trial introduced, these are a lot of lyrics. That means a lot of songs. The jury's going to hear all those songs. We have two experts on this. If to add to a trial that's going to take, there's no, in my opinion, not going to be 3 months. It's going to be a year. That is going to be a substantial part of the year. So I ask you to evaluate it. If it even comes in, if it even gets through First Amendment protection, please look at it under 403 for that analysis as well. And that's what they did in the Williams case. That's why I gave it to you. And that was decided, as you said, December 9th, 2022, and then adopted by the district court. The next one, Your Honor, and it was emailed to you, I believe, by the Honorable Doug Weinstein. I asked him to, and I thank him. And that's Commonwealth of Massachusetts versus Gray, G-R-A-Y, I apologize. And that is 978 Northeast 2D 543, 2012 case from the Supreme Judicial Court of Massachusetts. And what the court held in that case, and you should have it on your email, is
I do.
Okay. And this is in Division
What page of 17 you asked me to do?
See, bro, I'm looking and I don't really know, dog, on this.
Different than.
See, this is why I be saying you gotta wait till everything come out in court, because the way stuff be getting worded, I be getting confused sometimes. I'm not gonna act like I know it all when it comes to this shit, bro. Because I'm reading shit and I'm like, just the way this stuff is breaking down, the plea deals, the separation of the cases.
Exactly.
On page 14, bottom of the page.
Thank you, sir. And what the court said, if you turn, well,
All right.
let me see here. To the paragraph that begins with, even if the video had contained direct statements. So let me find the page. Okay, it should be on page 15.
Yeah, I think in this case, there was no issue as to gang affiliation. In fact, the defendant was willing to stipulate to it.
Well, what they wrote.
Willing to stipulate to it, and the court, said, it shouldn't have been admitted because it was minimally, if at all, probative and highly prejudicial. And basically it said here that evidence that posed a risk of unfair prejudice need not always be admitted simply because the defendant has opened the door as to his admission. The judge still needs to weigh the probative value and risk of unfair prejudice in terms of balance favors admission. So that's consistent with our law.
Okay, and then on page 16, with the state saying about their gang expert, it is
that's a police officer.
Yep.
Who's qualified as the expert without more.
Yep.
Okay.
Cannot without more be deemed an expert qualified to interpret the meaning of rap music lyrics. So that's why, again, I don't believe that the state's proffer is well founded. And then the last case for now I'd like you to see, and this is also recent, this was decided October 20th, 2023. It was emailed to you. And yes, the Honorable Doug Weinstein, God bless you. It's United States versus Donald, D-O-N-A-L-D. And that is,
I have it, sir.
2023 Westlaw 6958797. And this is the Western District of Connecticut. It was just decided. And I have to find out where in the email, but it's in Division 6, Rap, Music, Lyrics, and Video. And let me just find that. It's on page 20 of 32. It's Division 6, Rap, Music, Lyrics, and Video.
I got it.
And then on the 1, 2, 3, 4, 5, 6, 7th, it's actually on the next page. seventh, it's on the next page, the third paragraph. So it's on page 21 of 32. It starts with the issue of prejudice.
It doesn't tell me anything that Georgia doesn't tell me.
Well, I think it answered your question earlier. You said, what's the prejudice? The issue of prejudice with respect to the...
No, I didn't say that, Mr. Steele.
So you said that...
I did not say that. Okay?
No.
I understand what I need to do in terms of the prejudice prong. Okay? Under 403. I get it.
Okay.
I don't need any other cases from any other jurisdictions. We have plenty in the state of Georgia, which give me a lot of information on how I'm to interpret that in terms of legal relevance.
Okay. I just like to highlight this one.
Mr. Steele, please, let's move on to something else, okay? I don't need to cover 403, all right?
But I think but under 403, that's what I'm trying to say. It is so prejudicial. It's just so, this
Told me that at least 10 times already, okay? I get it.
Okay.
That, so tell me something else that I can use in order to determine whether or not it's a threshold issue, I'm gonna allow this.
All right. So next, if you don't mind, and it was emailed to you as well.
So for everybody here
earlier today
that's coming in, this is real time right now. It's going on 8 o'clock in Atlanta. I can imagine it's a 12-hour courtship. Maybe they came in at like 10. Let me see what they chat is saying right now. They still up in there. I'm locking in with everybody in the chat. Any questions? Still going for the kill. Damn, the judge shut down 2 lawyers' idea not to use the lyrics. Yep, they trying to get the lyrics. So we got to see. Well, we don't know what all evidence is and isn't there. So I'm not going to come on here and pay. I got to see everything play out, bro. That's just me. I got to see everything play out. And I'm tapping in with the chat real quick and we'll move on while they doing this little part. See what they are.
you should see everybody. I sent it to prosecutors earlier today and the court just now. And
I'll consider, it'll be considered under 104 analysis.
I got to see all the evidence. That's all I'm on.
You could read this yourself, but this is pretty spelled out. And with the court's permission,
You got it's a, for lack of a better word.
I say this, the trial ain't going to last as long as it was at first.
A song and an album, the artist, and the video clip, YouTube timestamp on it, and a link to their life. Going from references from Capo to Big Dog Assist to Wed Rings and Red Bottoms to Snitches, Kill You, Shoot Up.
She sound bad in the courtroom.
Switches on our blocks, smoky like a blunt, hose set up, drug reference, bodies on bodies, murderous wet blood, pistol gun, red bandana, head honcho, FN's Choppas. That's Charlie Hotel, Oscar Papa, Alpha Sierra, King Cobra, I'm the Principal, Boss, Perfect Leader, Sir Codeine, Shoot You, Anti-Police, Mixed Red and Green, syrup reference, not gang reference, Running from Police, Killing Cops, Mob Ties, Red Like Elmo, Wipe a new nose. Never killed anybody, but I got something to do with that body. I'm a general. Shoot 100 rounds. Shot his mommy. Give the lawyer $2 million. Throw your setup.
Okay. So these are the lyrics that are at issue. So I spelled them out for you and the parties. I took them from the state's motion and indictment. And the first one is from the motion, and it's number 1. The lyric is, I was a capo in the hood way before a plaque or a mention. And we gave you, as you said, you could just click on it, the YouTube site for the video so you can see it yourself. But then I gave you how common these words are, this theme is. And if with Miss Edwards' permission, if she can share the screen, Your Honor. Okay, the Zoom link ended. But Your Honor, if you just take some time and look at it, which I know you do. But the next one underneath where I have the first one of Jeffrey Williams, and I quoted the lyric that the state wants, is Capo. That's El Capo album, Jim Jones. And if you click on it, you will see that that other artist says similar things. The next one I quoted, feeling like Jim Jones, and I'm Capo, Money Man, did that. Next one, my other Capo is in big A blank S conglomerate called Death Row Snoop Mother blank Dog. That's Toss It by Tupac. The next one is Capo Head Honcho on the song and the album Phoenix by A$AP Rocky.
Okay, but what does that have to do with, the state's not gonna show me all these, or it's not gonna hopefully show the jury, and hopefully you're not, these other particular songs, so they're not really relevant for the matter in question.
Aren't they?
Say again?
Aren't they though?
They're not.
The state is saying, Your Honor, these words are so particularized that they go to this crime.
No, they don't. You have to look at them in context. And they're also looking at it from the sense of whether or not Jeffrey Williams authored this, or and the other circumstances that go along with it.
Don't you think it's relevant that calling yourself a capo, that the state stood up here earlier today and said, I was a capo in the hood way before a plaque or a mention, and that means that it's organized crime. You heard all that.
Well, capo common meaning, they could certainly can mean the head or leader. And that depends on what a jury decides to give it in terms of meaning.
But if it's so prevalent in this industry, that's what I'm showing you. I'm showing you that it's sung about the same type of topic.
But the state's trying to say that it may go to Mr. Williams either being a leader of this particular entity. And if he's singing or rapping that I'm a capo in the hood, that might be something that a jury might find relevant to show whether or not he's actually the leader or not. They don't have to, but it's relevant for that particular purpose.
So then I'm going to show that every single other person who sings about that is common.
But they're not charged with in the indictment. So it wouldn't be relevant for
they're
that.
not particular. These are not like, oh my gosh, you nailed I'm just using Donovan Thomas. You nailed the shooting. He was shot from a drive-by on Saturday, the 10th day of January, 2015, on near Northside Drive in Atlanta. That's particular.
Okay, but capo may be a word that if Mr. Williams is artist, okay, or that he uses in this particular song. And whether or not it has the meaning that would be relevant for admissible purposes in this case is a separate issue.
But doesn't it mean something under the First Amendment analysis that a lot of people sing about that topic?
Is anybody in Atlanta right now?
He's using a word.
All these people are using the word.
He's using a word.
All these people that I told you are using the same word.
But they're not charged in indictment in count one.
Exactly. That's the point.
But that's not the point. The point is whether or not it's useful to show membership or leadership.
It's useful to show.
And you're taking it out of context. You're taking it out of context.
How's that?
Because you're pulling one word in a particular sentence that has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 words in that sentence.
What the state did.
They're putting the sentence in terms of context. You're pulling out the word capo and you're saying, well, everybody else is rapping about capo or singing about capo. So that's protected speech.
None of those other words matter.
Okay.
I was a capo in the hood way before a plaque or a mention. They're using it because I'm saying I'm a leader.
Mr. Steele, I will give you that other people may utilize words that
We're gonna get a confirmation today though, EJ.
Somebody
Getting a confirmation on the lyrics today.
may also use in those songs. I'll give you that. But whether or not they're admissible or whether or not they go to a particular purpose, that's another thing. So
I don't.
that's for the jury to, if it's admissible as a threshold matter, the jury's gonna have to decide whether or not, like in the first one, Capo, whether or not that is attributable to your client being the leader or, leadership position, or singing about that, hey, I am the head of this particular entity.
But Your Honor, I go
So
back.
that's definitely relevant in terms of, whether or not the jury decides that is another thing.
I don't want to go to the jury.
Well, I know you don't
I
want
want
to,
you
but
to-
it might.
I want you to exclude it because
I'm probably not going to exclude that one. I'm just going to tell you that, because that
Mm.
goes to, for a number of reasons, it can go to show whether or not, as Ms. Hilton pointed out earlier about 4 hours ago, whether or not your client actually is the leader of this particular gang. Now, that's assuming also that we have attribution, authorship, and a foundation can be laid.
how about the First Amendment though?
I don't believe the First Amendment is going to cover that one.
It's so unparticularized, and that's the whole point.
Okay, Mr. Steele, again, they got to be able to lay the foundation. If they lay the foundation, I'm telling you that particular one would be admissible.
Well, I don't know how it gets through the First Amendment when all these other people are singing about it, but I respect this honorable court. But that's what all this is. All of this, Your Honor,
And D3 is for my consideration, but in each one of those categories that the court read off, and that you have listed other songs about that or other references, like I said, I'm not saying that other people haven't rapped or sang or written about those particular lyrics. And and those particular individuals, they're not charged or referenced in this particular indictment.
but their lyrics shouldn't be used against them.
Well, it depends on the purpose. Again,
You just have a lyric, a common everyday lyric.
they're not punishing or seeking to punish or seeking to introduce and criminalize your clients, if it is your clients, artistic product under the First Amendment. They're not trying to do that.
I think they are.
Yeah, and that has been the assertion by several folks that's what's going on. I'll admit or exclude this particular evidence based on the rules of evidence, not because it's going to be First Amendment's on trial. If it does fall within the First Amendment, then I'll apply a particular analysis. If it doesn't, then I will look at whether or not it falls under the actus reus, mens reus, logical relevance, other offenses, 402, any of the 24-8, 801D2A, 801D2B, 801D2E, 24-8-804B3, and the intrinsic, and the other statutes under 1615.
Man, they've been at it all day, y'all.
1659. And the last thing I will do is determine under 24-4-403 the legal relevance. And if it meets all those gates or the gates that are applicable to that particular statement, I will admit it. If it fails, I will exclude it.
All right. Well, I'm just going to then stop in place because I hear you clearly. I'd like you to look at one note, if you don't mind, on that same email. If you could just turn to page.
What page of D3, sir?
It should be 18. It's number 21, boss.
All right, hold on. 18 of 23, page 18?
It says 18 on the bottom of my copy.
Yes, sir. 20, and it's the 21st reference to boss.
And the lyric that the prosecution wants to put in is, quote, "I'm a boss. I call the shots." If you allow that in, Rick Ross on the song Boss said, "I'm the biggest boss that you've seen thus far." Meek Mill on "I'm a Boss" said, "I'm a boss." Bodak Yellow, Cardi B, the artist, said, "I'm a boss, you a worker." This goes on and on. What I'm trying to...
Okay, but again, they're not charged with anything in this particular indictment.
So is it that the First Amendment steps aside when a person's charged?
No, but it's contextual and it's fact specific, and it depends upon what they're trying to link it to. We're not bringing Rick Ross, Cardi B, Young M.A., Meek Mill, formerly Drake, or Post Malone in here to talk about any of those things, or they're not charged in this particular indictment. They sang about being a boss. If the state is trying to assert the reference, I'm a boss, I call the shots, goes to a leadership issue, or I'm the leader of the gang, well, then that might be relevant. But whether or not the jury decides to take that for the assertion and argument.
Now, I want to talk, y'all, but I want y'all to hear what's going on. I'm going to talk afterwards, man.
I am sure that you will probably examine or also make reference to these other particular artists, and whether or not they being the jury, finds that this is relevant for that particular purpose. Remember, we're not just saying, hey, Jeffrey Williams wrote about being a boss. That's not what the state's doing. They're saying that they're introducing this particular lyric for the assertion that Jeffrey Williams is the leader of this particular entity. Now, whether or not they being the fact finder, the jury decides that they wish to make that conclusion, they'll make that conclusion only after, if I admit the testimony and then I give them an instruction on how they're to continue the facts and evidence they determine them to be, and they decide that, yeah, based on that, as part of the totality of everything that they've heard, beyond a reasonable doubt, then certainly they can come to that conclusion. They may decide, hey, no, he's not the boss. Just wrote a song about it. But the state's going to present other evidence, and whether or not that individual collectively shows that your client is the potential leader of this particular entity, that's for the jury to decide.
Well, under that analysis, then if Rick Ross is charged with being a leader of a
Rick
gang,
Ross,
then his lyric comes in.
Well, no, not necessarily. It only if it's for a particularized purpose.
If the prosecution said he's the leader of the gang and that's what he said, then it's
if he says also, it might be an admission saying, hey, I'm the boss of this gang. They can consider it in terms of that. I mean, so.
But if you think that through what you just said, and I respect it, Your Honor, but then everybody who in this realm is performing music and saying those words can be used in a criminal case.
I don't think, you're going to have your opinion on that, Mr. Steele. I'm bound by what's been presented in this case. I certainly can't give you my personal opinions on it, but in terms of the states, I'm laughing because we're being timed out on a lot of stuff that my computer just decided to want to restart. So, so what I'm saying is that as much as you think that they're trying to criminalize or they're trying to admit statements that would be otherwise that may be classified as free speech, it's the analysis has to be one or the other. So if assuming that's
good point, Otter Mosley,
consider that for whatever reason that it's introduced. I'm just not going to
just on GP, nothing to do with this.
Just for shucks and giggles on that. Just because your client wrote a song about that particular issue, it has to go to a particular purpose. My gatekeeping function is I'm required to do this. They're going to have to present the foundation as to it, and it has to go to an issue that they issue a proof that they have to at trial. They're not. I don't believe they're trying to say that because your clients wrote this song that he's a bad person or anything like that. I wouldn't allow them to introduce that evidence if that were the case, but. Sometimes, as you know, being an advocate, I do have to balance the 403 and legal relevance over over prejudice, and that's one of the the harder things I end up having to do as a jurist, but I got to do it. So, but the chart's helpful. It is.
And then finally, Your Honor, I'll move for the admission of Mr. Williams, number 4 dated today. It's a declaration of Adam Dunbar, PhD. And you've heard from him before. And that's a declaration. I already served it on the prosecution on November 3rd of 2023. Your Honor, if I did not move for the admission for purposes of this hearing of any of my exhibits,
I've already considered D1, I should say two. D1 was Mr. Weinstein's, and you have D2 and this is D. Yeah, D2 is the book, and D3 is the chart on the thumb drive. This would be D4.
Your Honor, I have more, but I hear the tenor. I understand the court's statements, and I believe you understand my issues. So I will be objecting, and I don't believe the state met any of its burden that it did have to introduce these lyrics. I asked them all to be excluded.
All right, Mr. Carlson, Mr.
Fair to assume that Mr. Steele's arguments regarding 403, we kind of segmented this. Are they adopted by Mr. Steele?
Unless you want to be excluded, I'm going to include them for everybody they may be applicable to. All right, Mr. Carlson or Mr. Floyd?
It'll be strictly Mr. Carlson.
All right, Mr. Carlson, while you wrap your thoughts around this, I want you to kind of address a couple of different issues. So if you want to write these down for me, just so that you encapsulate them in your argument. These are things that Mr. Steele brought up. In terms of the YSL and the protected speech issue, the chart that you gave me in States 19, that the First Amendment cases, do they apply that he cited to me?
Yeah, I'm good. We just a lot of shit going on. I thought they was gonna be done by now.
Them under a First Amendment.
I don't stay on here though. I want to chop it up with y'all
Second
afterwards,
is,
so I wanted it to end
if you could
for the
readdress
day, so we
Carpenter.
can just recap everything real quick.
Carpenter,
We straight though.
And thirdly is the propensity.
I want to recap
argument
everything with
that
y'all.
Mr. Steele made. And 4 is the protected, is related to 1 in terms of protected speech, in terms of proof of who authored these songs or the song lyrics you're going to seek to admit. And then I got 2 more things, not too much. Under 24/7/704B with expert testimony and the ultimate issue, mental state. Could you distinguish that for me or for us? And then if you wanted, the last thing would be Mr. Steele's under D3, the chart and the commonality of some of the words that he has mentioned to me, related to in terms of these lyrics, whether or not they've been changed or edited.
May I start with the final one, Your Honor? The commonality issue.
Yes, you can, sir.
And if I miss any of them, I'll run through at the end, and I know the hour's late, and
Any big time. Anyway, it's important. Any way you all want to address it.
In terms of the commonality argument, Your Honor, the
Prosecutors, man. Let's see what they saying. They just a prosecutor.
I've been asked to take a quick comfort break, Mr. Carlson. Can we do that? And then we can
At the court's discretion.
complete this argument. So let me go ahead and do that.
This is live, y'all. This is live. They finna take a break. I'm gonna put it up on my other screen because I've been looking up stuff on my other screen. I'm gonna put it on my other screen so we'll be knowing what's going on live, so I can tell when they come back on live. Let me see. I'm gonna put it on my other screen so I can tell when they come back from live. Hold on real quick, y'all. We're going to go back. This shit probably been on at least probably about 10, 12 at the latest. They might have started the afternoon. Let me go back to when they was reading the lyrics for y'all and stuff.
Because, I mean, you know, we're all here to, I'm here to kind of make some preliminary decisions, but
Certainly.
wouldn't it, I mean, if my art or what I am, my genre or what I am trying to assert is just happens to be criminal in nature, or maybe a statement against interest, or maybe some other type of admission, would the same rules apply?
Well, I think what you have to do and what your task is, you're fortunate enough to have this task, is to separate what is the expression of a character, an artistic character, from what the author or the lyricist is saying. Lyricists write things for characters to say. That has happened in music for years. For years. I like John Prine. John Prine, when he was in his early 20s, wrote Angel from Montgomery. I'm an old woman who comes from Montgomery.
All right, let me try to get to that lyric part with old girl. She was reading stuff earlier today. Try to get that for y'all real quick.
Into the U.S. from Juarez, Mexico. He pleads guilty in federal court, but he never has to face Delia's Gone. Delia's Gone, all these songs, by the way, are written before this. They could have used Delia's Gone, okay? She was low down, trifling, cold and mean, evil, grab my submachine, okay? I am a songwriter, you know. Then immediately, court said, they all, when I asked,
so all the defense, hold on. We go back to the beginning. Here we go. This part from earlier today for everybody coming in. This part right here is from earlier today. We're going to recap while they doing their short recess. I got it on my other screen, so I'm going to know when they come back in the courtroom so we can see what's really going on. But Thug is in the courtroom. They all up in the courtroom. We're going to watch this right here live right now, and they'll be back in the courtroom in just a little bit. I do want to catch the end of it. So until they come back, we'll they switched over to breaking news. So they're going to be back in a minute. So we'll see in a second.
And then we have, I'm at the top with the bro, the Ooh Head Honcho. Again, this statement came from Mr. Williams' song Who, which this was a compilation album where Mr. Williams is featured on the album, but this is his particular statement. Again, showing that he was at the head, or he is the head of this YSL gang. He is the leader and the head of this gang. And one that did not make the board, Your Honor, but was from one of his songs called F Cancer, which was released on Apple Music in January of 2016. He has a song, Got a Lot of Followers, A Perfect Leader, I'm a Boss, I Call the Shots. Again, I've already spoken about with Jada Myrick and Christian Eppinger wanting to get approval from Mr. Williams. But then we also have, Your Honor, as relates to Marquavius Huey, after it is believed that Marquavius Huey robbed a particular producer, we have text messages of Mr. Williams telling Marquavius Huey to take that stuff back or somebody's going to get killed. Again, showing that he can show his leadership, that people are going to do what he says, and if they don't, there's going to be a result, probably a negative result. So, Your Honor, these are just a sampling of the lyrics in which the state would seek to introduce for those various areas and reasons. And with that, I want to turn it over to Mr. Floyd.
Man. Shit get wicked, man.
The school, actually by an artist that goes by the name of Juice WRLD. and it's featuring Mr. Williams. The song is called Bad Boy. It was released on Apple Music in January of 2021. And Mr. Williams says, I shot at his mommy, now he no longer mentioned me. Now this would seem again insignificant if you're just looking at these words. However, in this, or that's at least what you should have, YSL, he will kill. And he's alleged to have done that, and you know I kill.
See how it go now, man. They put it on a whole fucking display. This is the lyrics. This is what the judge is fighting to get thrown out today, y'all. They have not started the live back up yet. They in recess for people that just coming in. We do want to catch the end of it, but we gonna let y'all see what they broke down today. We'll do a recap at the end and break everything down. Give y'all some updates on stuff with this case. There's been a lot going on, but we are here right now. This is on Law and Crime Network. They in the live? I think they ended the live. All right, they ended the live, so we'll watch this piece right here where they reading the lyrics. They ended the live, so I guess they ended the court today.
This particular grouping, these are
it's 8:25 out there.
The YSL enterprise. And so our first statement that we're going to reference is a statement in the song "Take It to Trial," which is with Jeffrey Williams, Sergio Kitchens, and DeMonte Kendrick. And this is a song that was released on Apple Music in December of 2020.
7 hours today.
And so this is Mr. Kendrick speaking, I rep my life for real, for slimes, you know I kill. Mr. Kendrick is charged in count 2 of this indictment with murder. That is the murder of Donovan Thomas. He is alleged, along with Shannon Stillwell, Demas McMullen, Justin Cobb, and Javors Bradford, are alleged to have planned the killing of Mr. Thomas, Your Honor. And so it is the state's contention that for his slimes, which all of them we have alleged are part of this conspiracy, part of this enterprise, YSL, he will kill. And he's alleged to have done that, and we have alleged that he has done that. So again, this is not just something that's just being said in abstract, but when you couple this with the evidence that will be presented in this case, it's extremely significant. It's extremely significant. Can this particular, as an example of the verse of showing the nature of the enterprise, again, going to the state of mind, the intent, the motive, the knowledge of the gang, as well as the enterprise, and again, some of the underlying offenses. Again, this statement would come in with Mr. Kendrick as a party admission, as to Mr. Kitchens and Mr. Williams as an adoptive admission, and as to all of the other co-conspirators and co-defendants as co-conspirator admission and declarations against interest. The second statement, which is from a song called Dream, which is again by DeMonte Kendrick. It was released on Apple Music in April of 2015. He says, hey, how you doing? I'm yeah, got it. I got bodies on bodies. Again, talking about the fact that he has bodies on bodies, which is the state's contention, when our experts will testify to, is that he got dead bodies on bodies, not just regular bodies, but just bodies on bodies. Additionally, in this particular song, Your Honor, Mr. Kendrick says, I'm with Thugger, that's my woody. And we solid, oh so solid. If I get caught, I'm gonna say nothing. YSL, bitch, we mob it. Again, if he gets caught, he won't say anything. That is the mindset of this gang, Your Honor. This is the mindset that if we ever get caught, we won't say anything, we won't speak, we'll keep it quiet. That's consistent with what we saw previously in another one of those lyrics, that this gang knows if they get caught, don't say nothing. Or that's at least what you should have some allegiance to. Again, going to showing the nature of the enterprise, the nature of YSL, and this is the nature of how this gang operates. This statement would be.
We're gonna shoot over here back to live. Shout out to homie, say they only living alive.
It's everything you wish for. Your site traffic is skyrocketing.
I don't know what's going on. They switched over Law and Crime Network. These are two different stations, to my understanding. But we live on 11 Alive now. We back live, y'all. This is live in real time, 8:30 Atlanta. This is 8:30 Atlanta. This is about the lyrics being used in court.
Are factors to be decided by the jury. Does this lyric, does the content of this lyric inform us something about whether or not this group constitutes an enterprise under Georgia law, whether or not it constitutes a criminal street gang under Georgia law, whether or not it demonstrates association with either on the part of the defendant, whether it demonstrates the nature of either one, whether it goes to whether or not this individual committed one of the underlying offenses in this case, or whether he was just joking, or whether he just likes to pretend. Those are jury issues, Your Honor. They're not authorizations under Rule 403, much less the First Amendment, to exclude the evidence. And that gets to a point, Your Honor, about the First Amendment. We heard, and I recognize this is a large case, and I recognize there's a lot of paperwork, and I recognize that there has been stress and an incredible number of unique demands on every person, court personnel, lawyers alike involved in this case. But we heard it was only today when we received this case law and Carpenter gets singled out. Well, I'm looking at the state's first lyric brief, Your Honor. According to the stamp I have here, filed December 1st, 2022. Page 3, relevant lyrics are admissible and do not offend the First Amendment. You know what case gets cited on page 5? Or in there? Carpenter on page 4.
They must finna go all night.
From Carpenter. It's not cherry picking from Carpenter. And again, Your Honor, this is what we were told.
It's live in real time, nigga.
So Carpenter's there, page 4,
This
which
is
goes
live
back to the state's initial argument.
in Atlanta, 8:30.
Volumes of material have been produced by the state on this issue.
I wasn't even planning on being on this.
To whether or not there's been an equivalent supply of authority the other direction. But I'll read directly from the block site from Carpenter. Carpenter argues that his rap lyrics and music video were improperly admitted to trial in violation of Federal Rule of Evidence 403, as well as that the First Amendment protects his rap lyric as a form of artistic expression. The case, Your Honor, footnoted there at footnote 5 on page 4, again, December 1, 2022. And of all the allegations faced by the state today, being able to move back in time wasn't one of them. The Carpenter covers both issues. And it says here that it pertains back to the other Carpenter case, the earlier one, the one at 372 Fed Sub 3rd 74. Well, we have, again, go through the 403 and First Amendment. First, they address the 403 in Carpenter. Rap lyrics are properly admitted where they are relevant and their probative value is not substantially outweighed by the danger of unfair prejudice. And then there are multiple, then there's another federal case cited for that. And a district court can thus admit them after conducting 403 balancing. Cite to another federal case. Next sentence. The First Amendment is no bar to the evidentiary admission of rap lyrics, whereas here the artistic expression is not itself the prescribed conduct. So I could continue reading, Your Honor, but I recognize the court's reviewed the briefing in this case. That is right there, over a year old, and somehow, and in some other, that this and other authority in this area was characterized as only appearing today. Now, Your Honor, that lets us know where we should go in terms of a First Amendment analysis here. The court performs that First Amendment analysis when it examines what use the lyric is being proposed for. That gets us back to the chart, Your Honor. does the lyric form the corpus delicti of the crime? Is the speech what is being prosecuted? That's not the case here. And the cases we cited dealt with threats. A threat can be prosecuted for those words. But in this case, the speech is evidence of the crime rather than being the crime itself. Might go to mens rea, might go to actus reus, might go to both. And it might apply to building a racketeering enterprise. It might apply to building a gang enterprise. It might apply to association, to either, both. And again, it might prove one of the underlying crimes. So that First Amendment analysis that opposing counsel has been asking you to perform is exactly what the state is recommended. Look at the use and make the determination. But there's nothing here that takes us into the area of the speech being the prescribed conduct. Now, going to the court's, some of the court's other issues, the foundations for, and again, opposing counsel, one of the lawyers here, and I don't want to.
All right, let me type in with the chat real quick. Shout out to everybody up here to keep it interesting, entertaining, man. What's going down? They live right now. Hold on, this might be old, bro. Now that somebody just said that. Hold on, nah, this ain't old. I don't see the judge. Hold on. Nah, this new. I'm tripping. This ain't old. You just got a different color code because old boy's sitting over there in the cut still. So shout out to everybody here, man. What's going down in the chat? Y'all holler at me who all up in here. I want to get the end result decision that they make today. If they make a decision today on the lyrics, they might carry this over tomorrow. This wasn't planned for me today. I wasn't going to even speak on this, but I seen it trending, checked it out, seen it was live online. I was like, nah, we do need to talk about this because I'm going to make a video about it. Anybody got any feedback? It's live now. It's on live right now, bro. This is live. This is really actually live. They took a recess. See, they took the recess right there. That's when we came from the other channel and came to this channel because Law and Crime Network ended theirs, and then this one they came back. See, this one they came back from the recess. This is all today. It feel like they using the same camera type shit. Yeah, Gotti, Young Thug, other guys on the back. But this the recess. This is their break.
Is everybody back at this point in time?
Yes, sir.
Okay, all right. Thank you, sir.
Everybody back.
The context. But yet that was, and again.
So we're going to just tap in with the chat until we get the end result real quick. We are live. It is going on right now. What we got going, man? I changed the filters for them in today's day. They trying to lose lyrics, but the lyrics are not confessions. They pressing for these lyrics for sure. Randy Hanson, my bad. Oh, who is he? This is a lawyer, I want to say, on representing somebody on one of the other ones. Shout out to everybody that's up in here. Who all up in here, man? Who rocking with the channel? This is on 11 Alive. Shout out to 11 Alive. They out of Atlanta. The other one was on Law and Crime Network. They be live streaming, so nigga just be, hey, we gonna talk about it. A lot of interesting stuff said today. The trial is starting on the 27th. Yeah, I saw where they brought up Rick Ross. They reference other rappers because of Young Thug saying that he was a boss. So that's why they brought up Rick Ross. They brought up Jim Jones because the capo. Oh, you saying you capo? Thug's defense and the other lawyer's defense is saying, well, man, these are just terms that they use as rappers. There's plenty of rappers using the terms. The judge is saying, well, these other rappers are not doing that. And they brought up Juice WRLD because of something he said on the song. Thug said on Juice WRLD's song. Something that Thug said on Juice WRLD's song. But we here, man. Y'all still rocking. It's on y'all, man. We on a participation type of time. I'm pretty sure. Oh, let me see what Thug Lord is saying. Let me see what Thug Lord is saying.
Yeah, for them, they use
Kind of line
those statutes. They can't use 404B or 418.
And it's nice that Mr. Carlson is popping now, but he should know that they missed all these deadlines already.
Now, have you heard, Your Honor?
Yes.
A, no notice needed for intrinsic evidence. We've demonstrated how this is all intrinsic.
Excuse me. That's not 404B
Well, that's the prosecutor.
or 418. He just said 404B and 418. Intrinsic act, you don't need any of those.
No, you
That's
don't.
not what Mr. Carlson just said.
That's our point, Your Honor. They never made an objection that this was, they didn't bring the issue to you, Your Honor.
What Mr. Carlson is saying is going backward. The state of Georgia cannot rely on 404B or 418. They blew the statute. They're supposed to do it prior to trial or prior to the hearing. A sufficient time. They did neither. To say now it's intrinsic, that is not what Mr. Carlson said a moment ago. So that's why I'm objecting.
And they also blew their deadlines as far as identifying the lyrics that they tended to use, and then they're at the same time saying, well, we didn't object to these specific lyrics early enough, when they never told us until, what was it, November 6th?
Well,
This week?
have you heard, Your Honor? Yes. All right, Your Honor, they're making my point. What I said was, this is not propensity evidence. That's why we wouldn't have had to notice it that direction. Does it form intrinsic evidence? Of course it does. However, nothing would have stopped the defense if they believed any lyric out there in the indictment or anywhere else should come through another route to file the appropriate objection. So, Judge, this isn't being offered for a propensity purpose. So, what we heard from the defense actually agrees with the state. We went to pains to demonstrate how it's intrinsic evidence. And again, for those guidepost cases, we noticed it's up to the objecting party to make a determination what they don't want in, especially when the evidence is relevant. That's Rule 402. So to say that somehow the state ought to, and again, these cases talk about that being overly burdensome on the government, go out and search and find certain matters that it believes it's going to bring in and believes somehow would be objectionable, identify it, put it out there before the defense, who's actually the one who should be making the objection to it, is really the opposite of where much of that material goes. However, my colleagues on this case actually did go through and go that extra mile and provide opposing counsel and the court with a list, and then provided detailed information on how all of this integrates in the case through Deputy District Attorney Hilton today. So, Your Honor, in terms also of the Rodriguez issues, and I will point out for the court that the triangle diagram, as far as how 1615-4A operates, that was in Your Honor's materials.
How y'all feeling, chat? I know it's a lot of new people up in here on this live stream because of the trendiness of this topic. So for new people, man, how y'all feeling? Do y'all want to come in? My supporters that's always in here, you know, let me know. People who catching my live for the first time, man, this is a channel we do like to interact with the people, man. We're going to get back to what they saying in a second, but I do like to interact with the people that's watching, the people that's looking. Let me know, you know what I'm saying? How y'all feeling? Y'all want to continue to watch this? Y'all want to end it? Y'all want to keep? You know what I'm saying? Y'all let me know. Y'all getting burnt out or y'all still want to watch? Get active in the chat. Let me know how y'all feeling. At least 10 people. Let me know something. We ain't tripping on no donations, but we need participation over here, bro. That's what keep the thing entertaining for shit show. What do you say? Don't nobody play store. Keep rocking. These motherfuckers don't want to use the lyrics to create prejudice towards them boys because they know violent lyrics will have the jurors. Keep going. Keep going. I want to keep going on it. So to me, I was going to go catch the Rockets game, but you know what I'm saying? I'm here. If y'all want to keep it going, we're going to keep it going. If not, I'm going to go catch this Rockets game or something. It's on y'all. Get into something else.
Actuality case law provided. Now
it's on y'all in the chat. I'm giving y'all the option, man.
704B does not prevent an expert witness from explaining what gang symbiology means, what might in the gang content certain lyrics mean. It doesn't prevent that at all. What 704B expressly forbids is experts invading the province of the jury by stating the state of mind of a criminal defendant if that state of mind is an element of the crime in which they're accused. In other words, it's a much different question is, well, within the context of YSL, what does I've got bodies on bodies mean, according to your experience as a gang expert, to, well, did the defendant act with criminal intent when he committed murder in your experience? That's the forbidden inference in 704B. And even then there are limitations. For instance, 704B does not prevent an expert from drawing conclusions about intent so long as the expert does not profess to know a defendant's criminal intent. So we see also Chief Judge Glanville, on the issue of, if the court can draw me notice here, the expert witnesses, if I may have one moment, Judge. Expert witnesses providing information along those lines. I'm going to read now just quickly from the United States versus Smith. Apologies for bending forward, Your Honor. 919 Fed Third 825, 919 Fed Third 825. That's 4th Circuit 2019. And again, talking about an agent testifying about coded terms among drug users drug dealers as an expert. Now, there's another case here from the 9th Circuit where there were some problems with the way the prosecution qualified the expert, but that's different than the content. That's United States versus Holguin, Holguin, 51 Fed 4, 841. 51 Fed 4, 841. That is a 9th Circuit case for 2022. Again, talking about experts giving the meaning of gang terminology. So
he making this shit kind of boring, y'all.
The position that's somehow barred by 704B is just a misreading of 704B, which is sometimes called the Hinckley rule, related to the person involved in the attempted assassination.
I'm gonna tap in with y'all real quick before we get up out of here, bro.
Time in which 704B
I'll update y'all tomorrow on the decision. This is on 11 Alive, and I don't know if Law and Crime went back live.
When it comes to Johnny Cash, we didn't hear one thing from the defense that Johnny Cash was accused of killing that person. We don't know if there was even a murder. And in none of those cases where we had the supposed comparisons, did we have any mention of any motion from the state, motion for the defense, or ruling from the court on any of those issues? So again, those positions were of no moment. At best, they're alternative explanations, perhaps fodder for final argument, but not admissibility issues. The same goes, Your Honor, for some of the other areas that were covered. When we heard things like, this is all just fantasy. Your Honor, someone could look at that indictment and see one thing for sure, that's not fantasy. People are dead, murdered, and a gang exists. Those aren't fantasies. This terminology here, again and again and again, the deputy district attorney.
Well, it got turned up now, though. I ain't gonna lie. It done turned back up a little bit. Hold on, he done brought a nigga back in. I gotta go get something to drink. He done brought me back in. Hold on, let me get something to drink real quick.
That's not fantasy, Your Honor. That is tragically real. And if the position is going to be taken at some point that somehow this is all just a form of artwork, again, as the cases have informed us again and again and again, that's jury material, not exclusionary statute material. So several other points, Your Honor. As to this, it was interesting, when we were Speaking about Mr. Kendrick, the "for slimes I know I kill" line did not seem to be as much of a feature of the argument. That's definitive, that's forceful. But in terms of the song Dream, my colleagues have told me that the 2013 was a hypothetical. I'm looking to my left to make sure I'm correct on that. It was a typographical error. But regardless, and it's actually that 2015 date, I believe, is the correct one that the court read, and that would be in our more current materials. That was repaired. But that gets to this date with regard to 403, Your Honor, and when did something happen? All of that discussion really seemed to bypass that we've got a racketeering and gang case here. And this criminal organization has endured. So statements that are going to relate to some factor that's going to build a gang count or build an enterprise count, per the decision of the Supreme Court in Kemp when it comes to the co-conspirator hearsay exception, they're not timed out because of some constituent crime, because they go to support the case of evidence leading to proof of the organization's existence, its nature, association with it, whether this crime represents participation in the organization.
All right, y'all. We'll be back. Got turned up for a little bit right there. Shout out to everybody in the chat, man. Shout out to everybody who be supporting the channel, who rocking with me. Let me shout some people out up in here, man. Y'all type something where y'all from. This the time I'm rocking with my people, tapping in with my supporters. Appreciate y'all most definitely. If y'all rocking with me, get up in the chat right now. Anything people want to say, what y'all, you know what I'm saying, how y'all feeling, what y'all think about everything going on, anything else y'all want to tap in on right now with me, any opinions on what's going on out here. If it ain't nothing too crazy, we'll get into it real quick before we get up off of here, man. Let me know something. How y'all rocking? It's a lot going on in the game every day now. Can't even keep up with all this shit. I remember at one point in time, you'll wake up, it'll be one thing to cover or two things to cover, three things to cover, but now it'd be like 100 things to cover. Too much shit to cover. Shout out to 40 Cal. Shout out to Hustle Muscle TV. Shout out to 130 World. Shout out to Voice Box of the Block. Shout out to Soldier. Tony Snow, 2 Trill. Everybody who be tapped in, Wings on the Plane, anybody who tapped into the channel. A lot going on in the rap game today. We got this going on over there, this going on over here. Podcast shit going on. Nigga, I've been so tired up, I ain't even had time to get the clips out from the podcast like I wanted to, but we gonna drop some shit. We got a lot more coming, more interviews, more everything, man. Y'all make sure y'all subscribe to the channel right here, Urban Politicians TV. If you ain't subscribed, hit the subscribe button, hit the like button, come back, interact after the live, get up in them comments. Whenever I drop videos, y'all niggas comment, interact, and make the experience, man. We want the channel and everything that come on to feel like an experience, man. I saw that Tony 2 Trill, the Rockets up 15. Israel war going on, that's about to affect us all. I don't know. There's been a lot of wars overseas that don't affect us at all. I don't know if it's going to get to that level. I doubt it. You know what I'm saying? Who holding bruh? Dylan Brooks? Shout out to the Virgin Islands. Shout out to everybody who be tapped in, man. It don't go unnoticed. I appreciate y'all. What else we had going on, man? Joe Budden addressed the fight thing on the other day. Rollo got released from prison today. Nearly 6 years for people who been hip to Urban Politicians TV. I got started Urban Politicians TV on YouTube, on the YouTube side. I probably kicked it up and turned all the way up in I turned up in around April 2018, and I was covering Rilo then. It's crazy because I covered Rilo going into prison when he first got arrested. I was covering all that. Now he's coming home. And it's a few artists I did cover them in that manner. Like I covered them before they was going to jail or right when they was about to go to jail. And then shit, I'm here still covering when they come home. That happened a few times. Shit, I'm 5.5 years doing this shit every day. Every single day, man. YouTube, rap, hip-hop news, world news. It's so much shit that I really want to cover that I just ain't been having time to do. I don't be having time to shoot the shit, edit it. I do shoot a lot of shit, though. Don't get me wrong. I drop a lot of shit.
We've seen, and we haven't drawn a moral equivalency between the YSL rap, gang lyrics, and evidence of racist lyrics in hate crimes cases. But as we've said before, there's a legal equivalency there in terms of the rules of admissibility. So once again, Your Honor, the gang lyric evidence in this case
Here we go.
is proof of actus reus and mens rea, not only of the underlying offenses, but of the racketeering and gang charges. The state is
Hold on, y'all think
offering
we
these
finna
for the
get there?
evidentiary purposes.
Let's make a call real quick. What happened? It paused. They might have ended that shit.
Judge Pinson, back when he was Judge Pinson, and Stockard versus Rogers.
And I'll issue my ruling, and I'll tell whoever the
Hold on.
prevailing party is to prepare a suitable order. So if you all could come back tomorrow morning for 9:30, I'll have a decision at that point in time, okay? All right, so State, Ms. Hilton and Ms. Love.
Let's go back real quick, y'all.
For the firearms examiners.
This issue, who have considered this issue have, as we've said before, there's a legal equivalency there in terms of the rules of admissibility. So once again, Your Honor,
He fucked up on the part when he was talking, man. Damn. I wanted to hear what the judge was. I think he said in the morning, though. Did y'all hear it? Chad, who's still in here with me, man? Who's still thugging with me, man? Hit that like button, turn it up. It's about to come back on. Dang. Who's still in this bitch with me, man? If you still up in here, hit that like button, man. If you ain't hit that like button, go hit that like button. It's free. Turn it up. I wasn't even pressing telling y'all to hit the like button, but you know.
Yes, I see my investigator coming up.
Okay, all right. Well, I'll take those up as soon as we decision at that. I'm going to take the matter under advisement overnight. It's almost 9 o'clock. It's been well argued, well briefed. And what I'll do is we're supposed to start tomorrow morning at 9:30 with your firearms and other particular individuals that indicated to me tomorrow. What I'll do is I'll take the first part when we all come at 9:30, and I'll issue my ruling, and I'll tell whoever the prevailing party is to prepare a suitable order. So if you all could come back tomorrow morning for 9:30, I'll have a decision at that point in time, okay? All right, so State, Ms. Hilton and Ms. Love, are you all otherwise prepared for the firearms examiners, Mr. Barini, and microanalysis, the gun residue, the blatant print examiner for tomorrow?
Yeah. Yes, I see my investigator coming up.
Okay, all right. Well, I'll take those up as soon as we finish this. I will make this ruling, and then I'll cover as well. I have taken a look at the jail call between the three individuals to finish ruling upon that issue in terms of residual hearsay. Ms. Love, I was not, as much as I tried, I was not able to, until later today, I got our tech guy to load the evidence viewer on my computer. So until I have a look at that, I'll go ahead and I'll continue to defer that issue. But I've read the transcripts of both witness A and B. I'd like to take a look at just finish taking a look at that. And then, Ms. Hilton, I know we need to complete the other extra argument on 418. So I'm, depending on where we are tomorrow, but my goal will be for us to make a ruling on this issue. So Mr. Carlson, if I could ask you and Mr. Foy to come back in the morning, that would be definitely appreciative. And I'll make that ruling in first, and then I'll release it to you, and we can go on to some other things we have, okay? 9:30.
Yes, sir.
All right.
Tomorrow is on this lyrics issue and the blatant and print.
Can everybody please be quiet? All right. You didn't hear what I said, Mr. Steele?
I did. I got confused. Are we doing the residual? I know it's Mr. Matthews, but residual hearsay, and then I heard you say something about 418. That's what I heard.
No, I was stating that I listened to the tape, the jail call. So I know I need to rule on them as of they're outstanding. I also need to rule on the witness A and witness B. In terms of whether or not they fall within 801 D2E, D2E, 1
Sure.
issues. Those are the two. I need to look at the tapes themselves. I wasn't able to get the viewer installed until today. The state's proprietary evidence reviewer. I have read the transcripts, so I still need to complete those. And then the 418. I have to complete the other acts. Ms. Hilton needs to complete that. Okay?
That's tomorrow, though. That's what I'm asking.
I don't know if it's going to be tomorrow or not.
Okay.
It just depends.
Okay.
I'm just telling you it's outstanding. I may pull the trigger on those tomorrow, but I know they're outstanding, and I just need to make a ruling on those.
Okay. Thank you, sir.
All right.
Your Honor, we haven't heard argument on the residual for the court.
On what?
We have not heard the.
All right, y'all. So he not even for sure if he gonna make the decision tomorrow, man. He ain't for sure if he gonna make the decision tomorrow on that. So we gotta wait and see, man. We gotta wait and see. Shout out to everybody who was here tapped in, man. If you ain't hit that like button, hit that like button right now. It's free. Get active, turn it up. We ain't tripping on the donations, but come with the participation. We need all participation. Get up in there, show the love, show the support, man. It's free to support. There's one thing about this shit, bro. It don't cost nothing to support. It take 30 seconds to watch the video, 5 seconds to go back and hit the like, man. It ain't nowhere in hell, nigga, they ain't supposed to be having a certain amount of likes, man. Y'all supposed to have the lights turned up on this joint. Y'all get up in there, show the support, man, show the love. We most definitely appreciate y'all. Y'all get up in there and support us, man. Get up in there and show us that love, man. Get up in there and show that love, man. Shout out to everybody up in here, man. We good, we rocking, we working, showing love. Shout out to SKSK. Shout out to EJ Rendon. Shout out to Javion Boyd. Shout out to 130 World. Free Jeff, free Yak, free Quay from Javion Boyd. I was just looking at the Rockets tickets online. Yeah, I was thinking about hitting the game Sunday. I think they playing the Lakers, or they playing them again on the. They might be in there later. What they playing at tonight? They probably playing out here tonight. Yeah, they playing out here tonight if the game already on. They playing again on the 17th. I might go to that game if it's here. I don't think it's in Houston, though. Damn, they don't play again to the January 29th. God damn. Tonight was the night to go if you was going to catch them. Shout out to Annie 411. Shout out to Tony 2 Trill. Jose Felix. 40 Cal. We appreciate everybody, man. Y'all stay up. Hit that like button on y'all way out for sure.